All right, if you're gearing up for your family law exams, you are in exactly the right place. Today, we're breaking down the specific legal grounds that make a marriage voidable. We're going to take what can honestly be a dense, kind of confusing pile of legal doctrines and transform it into the ultimate, easy-to-remember exam review. So, grab your notebooks, because by the end of this explainer, you'll have a rock-solid mental framework to tackle literally any hypothetical scenario your professor decides to throw your way.
Okay, let's dive right into this. Here are the 4 specific signposts we're going to master today. Ground 1 is impotency. Ground 2 is insanity. Ground 3 is force or fraud. And ground 4 is concealed pregnancy. And then we'll wrap it all up with a final exam review.
Ground 1. Impotency. Non-consummation of the marriage.
Now, a key distinction you absolutely have to remember for your exams is that impotency can actually be either physical or mental in nature. But listen, here's your classic exam trap. You must remember that sterility does not legally equal impotency. They are not the same thing. Impotency prevents consummation entirely, whereas with sterility or barrenness, normal sexual intercourse is still totally possible. So don't let a tricky multiple-choice question blur that line for you.
To really lock in that memory, the handwritten case notes from our source material clearly establish the rule. Sterility does not equal impotency, meaning normal sexual intercourse can occur. When you're sitting in that exam hall, I really want you to picture this exact distinction.
And to back this up, you need a landmark case precedent. Seriously, write this down. Samarsam v. Sadhana. In this specific case, the court firmly established that the surgical removal of a wife's uterus is not a ground for impotency. Why? Well, circling back to our core rule, it doesn't prevent normal consummation. This case is basically your shield against any exam question that tries to equate medical infertility with legal impotency.
Ground 2. Insanity. Mental illness and valid consent.
So this is a highly nuanced area of law, mostly because mental health itself is incredibly complex. To successfully prove insanity for an annulment, the petitioner has to prove a very specific threshold condition. The spouse must have been either incapable of giving valid consent at the time of marriage, suffering from a mental illness that renders them absolutely unfit for marriage and the procreation of children, or they must be suffering from recurrent attacks of insanity. It's not just about having a medical diagnosis, it's entirely about how that diagnosis legally impacts the marital contract.
Which brings us to a fascinating Socratic question. Honestly, the exact kind of hypothetical you're going to see on a final. If a spouse has a serious diagnosis, let's say schizophrenia, but that condition is completely manageable by drugs, is the marriage voidable? Think about the strict thresholds we just talked about. Does a managed condition render someone legally unfit?
The answer is no. And the precedent you need to cite is the 2013 case of Kalam Chandrasekhar v. Kalam Padmalata. In this case, the husband argued that it was impossible to cohabit because his wife suffered from schizophrenia, which included suicidal tendencies and violent behavior. But, interestingly, the court actually refused to grant the divorce. Their reasoning? The medical issue was deemed manageable through medication. The massive legal takeaway here is that a treatable, manageable mental illness just doesn't automatically cross the threshold for avoidable marriage. Now, what's really interesting when we look at the case notes for another critical ruling, R. Lakshmi Narayanan v. Santi from 2001, is how courts actually go about verifying these claims during proceedings. Because when someone claims their spouse has a childhood mental illness, the court doesn't just blindly take their word for it. They observe functionality directly.
In the R. Lakshmi Narayanan case, there were all these allegations of childhood mental illness and issues involving medication. But get this, during cross-examination, the court found the wife to be fully functional. Plus, the court noted that the couple actually spoke with each other prior to the marriage. Because she demonstrated full functionality right there in court, the annulment was refused. It's a perfect example of how empirical observation in the courtroom completely outweighs mere allegations.
Ground 3, force or fraud, coercion and the 1-year rule.
So this ground deals with consent that was obtained by force, coercion, or fraud, and that actually includes deception regarding the very nature of the ceremony itself. So the crucial point to memorize here is the 1-year rule. A petition has to be filed within 1 year of the force ceasing, or within 1 year of discovering the fraud. But beware the major exception. The court will straight up refuse the annulment if the petitioner continued to live with the spouse with their full consent after the force stopped or the fraud was discovered. You can't discover a fraud, happily cohabit for 6 months, and then suddenly decide you want an annulment. It doesn't work like that.
For your exam-ready case law on fraud, look no further than Somdutt v. Raj Kumar. So what actually constitutes fraud? Well, in this specific case, concealing the fact that the bride was 7 years older than the groom was ruled as a perfectly valid ground for annulment. Why? Because it fundamentally altered the material facts that the groom was consenting to. Keep Somdutt in your back pocket for literally any questions regarding material misrepresentation.
Ground 4. Concealed pregnancy. Pregnant by another person at the time of marriage.
Now, this specific ground has the strictest set of conditions out of all of them, and you need to tick every single box to win this argument in court or, on your exam. Here is your mandatory 3-step checklist. Step 1. The petitioner must have been completely ignorant of the facts at the very time of the marriage. Step 2, just like the previous ground, the petition must be filed within 1 year. And Step 3, which is highly scrutinized, there must be absolutely no marital intercourse after the petitioner discovers the pregnancy. I'm telling you, if you miss even one of these steps, the entire ground collapses.
And this brilliantly illustrates how those strict steps are applied in a real-world scenario. Take a look at the case of Nulawava v. Maratu Ambi from our source notes. The timeline here is literally everything. It shows exactly how courts pieced together the dates of marriage, separation, and birth to establish the absolute truth of the concealment.
Let's quickly summarize the facts of Nilawa v. Maruti Ambi. The couple married in April 2007. The wife lived with the husband for just 15 days, did not consummate the marriage, and then left for her parents' house. Months later, in October, she gave birth to a child. The husband argued she was pregnant at the time of marriage, and crucially, a DNA report proved he was definitely not the biological father. Because he met all the criteria, he was ignorant at the time, he filed in time, and there was no intercourse after discovery, the annulment was granted.
Final exam review, the cheat sheet recap. Okay, you've got the rules, you've got the cases. Let's move to our final review and see how this builds together so you can walk into that exam room with total confidence. Let's lock this framework into your memory. Ground 1 is impotency. Remember the trap. It is not sterility, and cite Sam or Sam. Ground 2 is insanity. The condition must be unmanageable. Otherwise, you get a Coulomb ruling. Ground 3 is force or fraud. Do not forget the strict 1-year timeline and cite Somdutt for material concealment. And Ground 4 is concealed pregnancy. You absolutely must hit all 3 strict conditions, just like in the Nita Wa case. Connect the legal ground directly to the case name, and you are going to ace those essay questions for sure.
Now, before I let you get back to your studying, I want to leave you with a provocative thought to really test your mastery. What happens when these grounds overlap? Imagine a hypothetical where a case hits the 1-year mark for discovering a fraud, but concurrently, the spouse's mental illness was heavily medicated throughout that entire year. Which exception rules supreme? Does the cohabitation override the managed illness? Chew on that as you review your notes one last time today. Good luck on your exams. You've got this.